Hey everyone, it's AB Stoddard at the Bulwark. I am delighted to be here today with a good friend and a genius of the legal profession. She is always writing for the Bulwark, and you've read her before. Kim Wehle is here with me. She's a law professor at the University of Baltimore and also an ABC News legal contributor. Her latest book, Pardon Power: How the Pardon System Works and Why, is out. You should read it. You should read her previous 3 books as well. Welcome, Kim.
Great to be here, AB.
It's great to be with you on actually a horribly serious topic. I've been meaning you and I have been talking about doing this on YouTube for a while now because it's such a serious, dangerous possibility. What we're looking at, I wrote about it on the Bulwark for yesterday. Election deniers are prepared for next week. Are we? Is a scenario in which if Trump doesn't win outright, people in sort of seeing a Harris victory materialize either in close counts or maybe it looks like she's outright winning swing states are going to begin next week a process where they can buy time and sow doubt. And what they can do is start at the very local level. Someone can refuse, or more than one person, to certify county results. They don't even have to do it in a closely contested county. They can do it in a county that Trump is winning well or won well, just by slowing down the process, refusing to certify at the county level. They buy themselves more time, they sow more doubt, and it threatens the state certification deadline. Ultimately, we have the Electoral College nationwide meeting and voting on December 17th. All of these deadlines are strict. They're all along a process that has to go smoothly. And if you want to blow this up, you can do this by starting at the county level. Courts, a few days later, will compel any canvasser refusing to certify to do it. But again, this could cost some time, and all their crazy stories that they talk about, which made them doubt the count, are the things that get into the bloodstream and increase tension and the potential for violence. At the state level, Kim, we're not expecting any problems because we have Brian Kemp in Georgia, a key swing state who, as we remember in 2020, refused to steal the election for Trump. And there are Democratic governors in the key swing states of North Carolina, Wisconsin, Pennsylvania, Arizona, and Michigan. Only Nevada has a Republican governor. He's not likely to bend to Trump's will and do anything. This basically puts the spotlight on the state legislators, where Trump can go and ask these chambers controlled by Republicans, one chamber in Pennsylvania, 2 chambers in North Carolina, Georgia, Arizona, and Wisconsin, to come up with alternate slates of electors. In 2020, everyone remember there were fake slates of electors. This would be different. He would pressure these state legislatures to pass these, to approve of them. And Kim, John Eastman argued in 2020 that state legislatures aren't bound by federal law and under the Constitution have this plenary absolute power over electors. At this stage, what do you see happening? If one or more of these key swing states, if their legislatures pass what they want in terms of electors, and they say, we just couldn't approve the vote reflecting the electors reflecting the popular will because we just can't trust those results. This happened here and suitcases there. And if they go ahead, it's going to be audacious. But if they do that and they present them to the Congress, what happens at that point?
Well, you outlined a number of things just to clarify. The vote count is the canvassers. The state legislature or the state secretaries of state will, as you indicated, likely certify the election. However, there could be a lot of litigation with the county levels refusing to certify, right?
Which costs money.
And you'll have to get a court to agree with the law and direct them to certify. And in addition, I think there's a big question as to whether, if they do certify, what are they certifying? Could all these shenanigans with canceling votes produce an undercount that is certified by the governor of the state? So we're assuming that whatever gets certified at the state level is the one that actually counts all the votes. And I don't think that is clear necessarily under the law. And I did a piece for the Bulwark on Bush versus Gore, which, of course, where the Supreme Court in 2000 handed the presidential election to George Bush with 537 votes, declining to allow Florida to do a hand count under Florida law because deadlines are deadlines. So I just want to say, as an initial matter, the deadlines are deadlines is good to one degree because we will see a certification at the state level. However, if there's still some shenanigans around which ballots get counted, and that goes to the Supreme Court, I think the answer would be deadlines are deadlines, and we don't care if there are valid votes that have not been counted. We have the precedent of Bush versus Gore that effectively says deadlines are deadlines. So I think that's actually a really important point that we miss when we hear about, ballot drop boxes being burned. We're hearing about people being denied registration or tossed off the rolls. We're going to see bullying at the polls, people feeling intimidated around voting. All of those things could produce an undercount that then is required to be certified. Now, you indicated, so assume we get through all of that and we have certifications at the state level, and then as you indicated, the state legislatures come in and say, no, we don't like what you did. We're going to throw all the votes out and do our own thing. That's essentially what John Eastman is arguing. There's two responses to that legally. One is actually, and this isn't something, AB, that people have talked about much. It's our old friend, the 14th Amendment. We heard a lot about the Section 3 of the 14th Amendment, whether someone who's participated in an election having previously taken an oath of office, that is Donald Trump, can be kept off the ballot. The Supreme Court said no. He gets to be on the ballot. They basically deactivated Section 3. But Section 2 addresses this. It actually says if, and I'm quoting, if voters, citizens of the states, their right to vote is in, quote, any way abridged, the basis of representation shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. I know that's a lot of legalese. Bottom line, essentially, the 14th Amendment says if you're going to start canceling people's votes, you lose your delegates in the House of Representatives in January. That you basically get discounted from the total. So that's what the 14th Amendment says. Now, has it been litigated, AB? No. There's some historical precedent for invoking it in like the 19th century. Has this gone to the Supreme Court? No. Could the Supreme Court do some, mental gymnastics, Cirque du Soleil, to get out from underneath the plain language of the Constitution again? 100%. This right-wing Supreme Court majority will do that. But the other good news is that the federal law, known as the Electoral Count Act, that's been in place again since the 19th century to manage this whole process of counting electoral college votes, that was changed and amended in 2022 to take this off the table. It basically says state legislators can no longer come in and do whatever they want. John Eastman is referring to this doctrine called the independent state legislature theory that also derives from the Constitution, where essentially the argument is state legislators have the final say, the final bottom line say on voting, no matter what anybody says, including state constitutions, including judges, maybe even including the United States Congress, AB. So I guess his theory would be, who cares what the Electoral Count Act says? The Constitution overrides that, and state legislators can do whatever they want. In theory, that could go to the Supreme Court. And honestly, we cannot predict, except they really like Donald Trump and they probably want to do whatever they can, the majority, to keep him in power based on their rulings to date.
So it's not without risk should the Supreme Court not rule in their favor because they potentially lose their delegates in January. So it is a roll of the dice. But in terms of the goal of buying time, of delay, of sowing doubt, of increasing tension and pressure on the members of the House Republican Conference to block in any way they can a Harris victory, it would still be worth the gambit, right? If you're thinking in terms of those goals.
Well, think about where we are. Absolutely. We're hearing this narrative, close race, all election fraud from 2020, when, let's be clear, the only election fraud that's been established in the court was on behalf of Donald Trump, actual tampering with voting machines in Georgia, right? That was all for the Republicans, no election tampering for the Democrats. But we're seeing this. So they're going to declare victory regardless of the vote count, saying, listen, it was so close. There's more cheating. It's being stolen. They've filed prophylactic lawsuits, these zombie lawsuits. I wrote about it for the Bulwark as well, kind of putting a marker down that they're going to revive these, because actually you can't go in and look at people's votes after the election, but they'll say, listen, we challenged these votes before the election. So we put our marker down. We're not reopening ballots. They're going to challenge all kinds of things. We're seeing some of that start. Then, as you indicate, there might be counties that refuse to certify. That will have to be litigated. And then meanwhile, we're building this idea of fraud, stealing, all this kind of stuff. Then you're going to have, as you indicate, the legislators could come in and say, this is our right, pound the table. This is our right under the independent state legislature doctrine. To be clear, the Supreme Court last year in a case called Moore versus Harper was given the opportunity to give a thumbs up or thumbs down on that theory that the states have the bottom line role. They declined to say yes. They did not agree with Eastman, but they didn't kill the theory forever, right? It could be revived. So they're going to say, oh, under the Constitution, this is the state's authority. Then we're going to see, we'll get into the House of Representatives. They're going to say, contested election. The Democrats are going to say, but what about the Electoral Count Act? You don't get this authority anymore. You got to cut out the delegates. They're going to say, wait, see what the Democrats are doing. They want to cancel our actual delegates in the United States Congress. And then they're going to say, under the 12th Amendment, we get to decide this. And we don't know, AB, you know more about this than I do, whether it would be the existing Congress or the new Congress. The new Congress should be sworn in on January 3rd, which precedes the date of the counting of the electoral count, the electoral votes. So if Mike Johnson's not in charge, that's a question. I mean, all of this, but the chaos is the point. And then we have, potential violence if we don't have it before on either side, right? So if it goes to the House and the House is insisting we get to choose, I think Kamala Harris supporters are going to be understandably outraged. If Donald Trump is not declared the winner in January, then I think his supporters are locked and loaded, ready to come out to vindicate what they believe was a stolen election in 2020. And we're not going to let this happen twice.
Okay, so what you were referring to is a contingent election. So for the viewers, if neither candidate can get to an electoral college majority, the election goes to the House, in which each state delegation gets a single vote. Republicans control 26 now and Democrats 22, with two states evenly split. So if Republicans, who are expected to maintain that advantage, were to vote, they would vote for Trump, obviously, and he would win in the House, which is in and of itself a constitutional crisis, and the public is not going to accept an election decided by the House. In terms of what you were talking about, in terms of House majorities being decided 3 days in advance, it is entirely possible that even if there's a Democratic majority, that Speaker Johnson, if there were recounts in close races still and litigation pending, might not seat those Democrats to create a majority on January 3. Let's hope there is no contingent election. What about the update to the Electoral Count Act from 2 years ago gives us, what new protections does that provide?
So it does a number of things. It says that the state legislators cannot override the popular vote in November. And just to be clear, this is kind of mind-blowing, at least for me. There's nothing in federal law or in the Constitution that requires states affirmatively to even count the popular vote. I mean, I mentioned this provision in the 14th Amendment, but the theory is it's the states that basically decide how to weigh the votes, right? So that was a problem in 2020. The electoral amendments say no. It's the law that's in place on November 5th that is what's going to determine how the electoral votes are counted state by state. The states can't monkey with that between November and December when they meet, and then those slates are what goes to the United States Congress in January. So they say that. They say it says number 2. So we're back to the contested election and what I mentioned in the 14th Amendment. It says, okay, say we've got a state, Georgia, where we know Republican enablers or Trump enablers in the sort of the election apparatus have been trying to create laws. They were struck down, but create new, not even laws, new policies that allow vote counters, canvassers to just challenge based on imaginary fraud. So let's assume that's one state where we've got counties that just can't decide. Okay.
Right.
And so Brian Kemp says, I can't certify something because I don't know what I'm certifying. That would be a state that has a failed certification. It then would make it a contested election. What the Electoral Count Act now says is you take all of Georgia's electoral votes out of the total. So it's no longer 270. It's a fraction of the new total that would then give you the presidency. But this is going to create all kinds of howls. It'd just be a disaster, right? I mean, it would be just PR wise and just the confusion for the public. But that's the other thing it does. The third thing it does is it makes clear that here, Vice President Harris does not have any authority to do anything other than gavel in the winner. It also raises the threshold for the United States Congress to challenge the slates. It used to be 1 or 2 people in either house could challenge it. Now it's a fifth of both houses. So if Mike Johnson or the Republicans wanted to say, we contest Pennsylvania's results, if Pennsylvania goes for Kamala Harris, for example, they would need, under the new law, they can't just make it up out of nowhere. They're going to need a fifth of both houses to agree with them. And the standards are a little tighter. They actually have to have some there. It can't just be generic allegations of fraud. But at the end of the day, AB, who decides if they can't dispute, if they can't agree on that, if the Congress disagrees on the law, then it goes to the United States Supreme Court.
And the goal would seem to be for Trump to get to a contingent election. That would be the cleanest, if you were him, to
it's
try
the cleanest
to block.
Because it's messiest.
Yeah, but he has the advantage. He doesn't have Supreme Court justices that could suddenly do the right thing. He's not rolling the dice on that. He's got a complicit conference in the House that will do.
Oh, if he gets to the 1/5, yeah.
I think that the contingent election scenario would be the goal for him. Okay, so quickly, it's very important for people to understand, as Kim said, you're really not allowed at the county level to refuse to canvass. You're not the person you're not an arbiter weighing in on any of the ballots. That's done. It's adjudicated in court and done in recounts and audits. Your job is to literally count a pile of things and say, this is the math, and you're not allowed to weigh in. It's not discretionary in any way. It's completely perfunctory. And it's important to say that because certification sounds like a word that implies discretion. And so I think it's really important that, and we have fanatics on the ground. I want to read you a quote from a lengthy New York Times report from over the weekend. And all 3 of these really excellent reports on all this stuff that people should read are going to be in the show notes. A Rolling Stone investigation, a New York Times report, and a Politico report. And I urge everybody to read them. The New York Times, Jim Rutenberg put it this way about locals who are willing to obstruct the results. For them, going so far as to block certification wasn't a partisan gambit, it was a patriotic duty. Though it might technically be illegal, it obeyed a higher law. So this possibility that we're talking about is very likely. And as Kim describes, the courts will rein them back, but it buys so much time and it creates hysteria. Okay, so Kim, there's other things going on today. The Supreme Court ruled on a case involving voter roll purges in Virginia. What is it going to mean? I did read that if you were purged, you can still get there. Anyone who is a Virginia resident listening to us, and you can re-register and you can vote. But tell us what they decided.
So back to our friend John Eastman. For the most part, he's correct that states decide how voting works, but Congress can come in and make national laws. So they did pass a law called the National Voter Registration Act. And in that it says 90 days prior to an election, you can't be doing mass purges. You can't be throwing people off the voter rolls. So Governor Youngkin, I think, 89 days in, one day past the threshold, issued an executive order ordering purges of, quote, non-citizens. And the Justice Department, as well as voting rights groups, filed lawsuits saying this violates the National Voter Registration Act. You can't do that. And both the lower court and a sort of a threshold ruling in the Fourth Circuit, the appellate federal court, agreed with the challengers and said this federal law preserves your votes 90 days until the date of the election. And then the Republican caucus appealed to the United States Supreme Court, wanting to overrule temporarily, to basically put on hold the lower court rulings. The lower court rulings were like, sorry, Virginia, you got to count these folks. And there was evidence that the district court, the lowest court, put in their opinion saying, this is such almost you're not using a scalpel, you're using a hatchet here. You are cutting out, there's evidence that you are purging not just non-citizens, but citizens, because you're not doing this in a careful way. And their argument was that basically that 90-day rule doesn't apply to people who are ineligible, that essentially if you're a non-citizen, you don't get the benefits of federal law. And sure, you might catch up some citizens too, but we've got to stop the non-citizen voting. That's more important than making sure citizens' votes are counted. So even if they are kind of on the chopping block too, this is for a higher cause. And by the way, the Supreme Court's also said you shouldn't be messing around, courts shouldn't be messing around with elections close to the election day under something called the Purcell principle. I mean, all of that I think is wrong in part because the Purcell principle is a court-made idea. We've got the National Voter Registration Act. Congress trumps, for lack of a better word, but Congress gets to make these rules and it's clear, right? The Supreme Court came in and as I said, no, we are going to side with Virginia and Youngkin. So these votes get cast aside until the lower courts resolve the entire lawsuit. And then we'll consider on another appeal whether they're permanently cast aside or not. But of course, at the end of the day, we're so close to the election. This isn't, by all accounts, a win for the vote purgers. Now, as you indicate, one of the arguments that the Justice Department made is like, listen, you can still purge individual voters on a case-by-case basis. You can't just do the mass voter purges. That didn't carry the day in the Supreme Court. But as you indicate, what people can still do is go and say, vote individually on voting day, right? The problem with that, and this is the other quick case that's pending now in the Pennsylvania out of Pennsylvania, the Supreme Court is being asked out of a lawsuit in Pennsylvania to say, if your vote is kicked out, you cannot cast a provisional ballot, that you don't get a backstop after the fact. I mean, it's under a Pennsylvania law instead of Virginia law, but it's the same idea that, if you're kicked out unfairly, you're kicked out unfairly. That's the argument the Republicans are making in Pennsylvania.
In a critical battleground. So when, what do we think the resolution is going to be in that? And when is it, is it going to decide the election?
these emergency motions go to an individual justice. And the justice for the Pennsylvania case is Samuel Alito. And he has given, I think until today, the other side the ability, the pro-voter side, the ability to file a brief on it. And then the court will vote on what to do. In the Virginia case, the three progressive, or frankly more moderate in this moment, I think it's unfair to call them progressive, but the more moderate justices, which are three of the four women on the court, Kagan, Justice Sotomayor, and Justice Jackson, they dissented from the decision to basically wipe out the work of the lower federal courts in Virginia. They dissented from the majority's decision to back Youngkin, which is that 6-3 same majority that got rid of Roe versus Wade and have done all other kinds of things. The Trump immunity case, overruling Chevron, really radical things. They're in the majority here. And so my expectation is AB, or I wouldn't be surprised if they side with Republicans in Pennsylvania as well and say, if you're knocked out for the wrong reasons, you cannot cast a provisional ballot. And all of these things, as we were talking about earlier, they go towards a forced certification of an undercount, and they also create an impression of fraud. Yes. An impression of, see, we got it. We caught them. These, the 72-year-old who, in Pennsylvania, you've got to have a yellow envelope. Then you put that envelope in another envelope. And that envelope has to be signed, and there has to be a date on it. And the challenge in Pennsylvania is on people who did not put the date under their name on the second envelope on their ballot. And you can imagine, like an elderly person or just a busy person might have just not done that part.
I would not have done that part.
Me neither. I was like, yikes, I might not have done that.
Yeah. Wow, that is really something. And we expect that imminently, that decision?
Well, Alito, again, asked for the briefs today, so I would think by the end of the week.
Today is Wednesday, yeah. Okay. Kim, thank you so much. And next week, if we're in the middle of a legal maelstrom, we'll be seeing Kim again. If not, it means that Trump won outright. And there's nothing to contest. Thank you so much, Kim Wehle. Everyone, thanks for watching. Keep it here on the Bulwark's YouTube page. We have stuff coming in all the time like this that you should be paying attention to. We'll see you next time. Thank you.
Thanks for having me, AB.